Okay, good morning and welcome to this webinar. My name is Burnett and I'm a partner in our insurance disputes practice. I'm joined today by my partner Ben Hardiman, and we both specialise in advising brokers and their insurers in respective E&O claims and risk management. Today, we're going to look at the anatomy of a broker's role and the duties that a broker owes to its clients and the common pitfalls that we see. But before we kick off, just a couple of points of housekeeping. Firstly, the session is being recorded and the recording will be available afterwards. Secondly, there will be time for questions at the end, so please do put any questions into the Q&A box, and my colleague and senior legal advisor, Harriet Strevens, will pick them up for us at the end. And if we run out of time, we'll deal with them after the session by email. So here is the agenda for today, and this is what Ben and I will be talking about over the next 20 to 25 minutes or so. And let me kick things off by giving an overview of the anatomy of a broker's claim. Now, whether it's a new client or renewal business, the duties that you as a broker will owe to your clients do not change. And from our perspective, when we deal with claims, we tend to see issues arising from one of the following areas that you see on your screen. So the first stage is the know your client, establishing the demands and needs stage. Now, this is the information gathering stage where the broker makes appropriate inquiries so that it understands the nature of its client's business and the main risks of that business. Stage 2 is then using that information that you've gathered to identify an appropriate insurance solution that meets the client's demands and needs, and which also represents fair value, especially if the new consumer duty applies. Then we move on to stage 3. This is the presentation stage. This is where the broker is required to advise the client on what information must be disclosed to insurers and about the potential consequences if that doesn't happen. And this is so the client can gather key information that it needs to present to underwriters and also present it in a way that enables the insurer to properly understand the risks that are associated with the client's business. We then move into stage 4, and this is where the broker is required to give appropriate advice so the client can make an informed decision about the scope and the level of cover that it requires before it makes a call on which policy to purchase. And then stage 5, this is the binding stage where the policy incepts or renews, and the broker needs to advise the client about the key terms and conditions of the policy that it must comply with. So that's the overview. Let's just look a bit more closely at the first stage, which is the information gathering stage. This is the know your client, establish demands and needs point. Now, this is where the broker is responsible for building a picture of the client's business. And we often see cases where there's a simple misunderstanding, miscommunication, or a failure to ask the right questions, meaning that important information is missed. Now, at this point, the broker should be asking probing or open questions to secure the information that it needs to know. In taking that approach, the broker is entitled to keep in mind the extent of the client's knowledge, understanding, and experience of arranging insurance policies. But let me just give you an example of a reported case which demonstrates precisely why asking the right questions and, importantly, open questions are so important. So in this case, called the Moonacre, the broker was arranging a policy for a wealthy yacht owner. Now, the insurer wanted to know if anyone lived on the yacht. The broker asked his client if he lived on the yacht, and the answer was no. What the broker didn't appreciate is that this was a pleasure craft. The owner employed a crew, and the crew lived on the yacht. The insurer relied on that wrong answer as a material non-disclosure, which left the yacht owner uninsured. Now, that claim arose from the broker's failure to ask the right question, and it left the broker exposed to what I would expect was a very large claim. And most policies these days are arranged on a statement of fact basis, and sometimes the questions asked by the insurer aren't always clear, and any ambiguity can introduce additional risk, which might be mitigated if the broker is to ask additional questions that sort of product further information that might be relevant to how that particular question is answered. Now, any further information gleaned can be provided to insurers as part of the risk submission to underwriters, if indeed there's any uncertainty. Now, not only should this kind of approach protect the client, but it will also protect the broker. The information gathering stage has always been a challenging area for brokers, especially if the client isn't forthcoming with information. But the risk has increased over the last few years because of how quickly our working lives have changed. And I'm talking about change that has been prompted by the pandemic and how technology is developing and continues to be introduced into our working lives, and how those changes have changed the way we work, where we work, and when we work. And as a result of all that, the risks that are associated with the client's business are constantly evolving. So how can a broker protect itself against the risk of miscommunication or against the risk of failing to capture important information and details that are important to the client's business? So here's our first risk management tip. It's really essential, in our view, that the broker records the information in writing for their own protection. But for that written record to be shared with the client and for the client to be asked to check the note for accuracy. You should even ask the client to let you know if you've misunderstood anything or if you failed to capture any important information or some of the information is inaccurate. We then move into stage 2. So this stage is about identifying an appropriate insurance solution that meets the client's demands and needs. The process will depend on the type and the size of the client's business, the client's experience, and precisely who you are speaking to within the business and how sophisticated and experienced they are at arranging insurance. Now, we have handled claims where the broker is accused of arranging an insurance policy where, for example, the broker in this particular case received a higher commission from the insurer in question than it would have received from other insurers on the market. And it's alleged that the broker preferred its own interests over the client's interests in arranging that policy. In this case, the policy that was purchased was inferior to other potentially more suitable wordings that were available on the market and that were cheaper and that would have potentially provided the client with wider cover. In another case that I can think of, a claimant alleged that the declining insurer had a reputation for refusing to pay claims and that this should have been flagged to the client by the broker. In this particular case, the client was able to show by speaking to other clients of the broker who had also been insured with this particular insurer and who had also had claims declined that there was a pattern that the broker should have told the client about. Now, this is quite a novel allegation and it's very difficult for the client to prove. But the key thing here that I want to draw out is that the client cited that the broker owed a duty of care not to expose the client to unnecessary risks. And that includes the risk of litigation with its insurer, which did ensue. Now, the broker is not required to advise on the amount of insurance that should be purchased, but it is required to provide information and advice that will enable the client to take further steps before making an informed decision about things like the level and the limit of indemnity under the policy, whether additional cover is required, for example, through excess layers, whether it requires advice from an external expert, like, for example, a surveyor, if you're considering building sums insured, or an accountant to help the business consider the business sum insured required for business interruption purposes or the length of the indemnity period. Now, business interruption or BI is a particular hotbed for claims. And in that context, the broker is required to explain how the BI sum insured is calculated and the importance of the length of the indemnity period. But it's for the client to decide how much insurance it should purchase. Now, we've seen examples where the broker, trying to be helpful to the client, either guides or leads the client's decision when it comes to fixing the value of the sum insured or the length of the indemnity period, when clearly that's a matter for the client to discuss with a valuer or its accountant or another professional advisor. Or alternatively, we've seen situations where the broker places too much reliance on information and financial figures that the client provides, even when it's clear that the client has no real confidence in the accuracy of that information. So before I hand over to Ben, this brings me to our second risk management tip. Now, to avoid falling into this trap, the broker should give clear advice as to the risk of being underinsured and to the possibility, if that happens, that the insurer may apply average and what that means. Now, if you want a reminder, if you missed it, then please do watch the session that my colleagues Andrew Tobin and Charlotte Clark delivered on underinsurance in our Cover Talk series, which is available on our YouTube channel. We have seen cases where the insurer has gone one step further. It hasn't applied average, but where it considers the underinsurance issue to be so egregious, and that's been driven in the insurer's view by the client's desire to pay a lower premium, that the insurer seeks to avoid the policy based on a material misrepresentation. Now, there might be a greater risk of this happening than you think. Just consider an example where the broker has a client in the construction industry, and the sum insured, let's say, for the cost of rebuilding its premises, is calculated based on the client carrying out that work at trade cost. Now, we can see in that scenario how an insurer might argue that there was a deliberate decision to insure on that basis, and if it believes it can avoid the policy, it may also take the view that that was deliberate or reckless and decide to keep the premium. Now, finally, just to close this section, the broker is not required to advise the client in respect of every possible type of insurance policy that the client could purchase. The broker is, though, required to advise to the standard of a reasonably competent insurance broker, exercising reasonable skill and care, as to what type of insurance should be purchased to cover against the main areas of risk for the client's business. That's brought me to the end of my section. Thank you for listening. I'm going to hand over to Ben to talk to you about the presentation stage.
Thanks, Liam. Good morning, everyone. So once you as a broker have identified which policy should be purchased and which insurers should be approached, it's time to make the presentation. So the broker's duty at this stage is to inform its client that they owe a duty to give a fair presentation to insurers. Now, what does that mean? I think the client needs to be made aware that they have to disclose every material circumstance that they know or that they ought to know. As part of that, what is a material circumstance? The client needs to be informed. So that is any information that may influence the insurer's decision about whether it's prepared to offer insurance, and if it is, on what terms and at what cost, so what premium. Failing that, the client has an obligation to provide sufficient information to put a prudent insurer on notice that it needs to make further inquiries. Now, there's no obligation to disclose information which diminishes the risk or which the insurer knows about or ought to know about. But there is an obligation, and this is enshrined in the Insurance Act, and I think this falls on the broker to ensure that the information provided by the client is presented in a reasonably clear and accessible manner. So risk management tip 3 for today, based on the claims that we deal with, this is the point at which, and this sort of harks back to what Liam said earlier, the broker needs to remind the client that the proposal form, the statement of fact, or the presentation document is based on the information that the client's provided. And hopefully that information is recorded in a detailed note. And as Liam said, we have seen some brokers provide that note to their client, asking them to address any errors or correct any ambiguities. Now, I'm not going to go into detail today about the consequences of getting this wrong. I'm sure everyone on the webinar will know about or will have seen Insurance Act remedies in practice in terms of how they can lead to cover being restricted or being pulled entirely. It is essential that clients are made aware of that risk. So finally, on this presentation aspect, in terms of the presentation of to insurers and the knowledge test, when your client is a business, the relevant knowledge is that of the client's senior management team and the individuals who are responsible for making the client's insurance arrangements. Now, that might extend to knowledge outside of the business, including that business's agents. So that could include brokers, and it could include accountants, for example. So I think as a further risk management tip for this slide, The important thing here is to advise the client that there may be knowledge or information that sits outside of the senior management team, the people who are providing the direct instructions, and the client needs to be asked to consider how best it can reasonably capture that information. Now, that might be to have some form of pre-inception or renewal audit of all staff, or at team leader, senior management type level of incidents that may give rise to claims. It might be speaking to the accounts team, the finance team, or even external accountants about current and future anticipated levels of turnover from the BI aspect. So then we move on to stage 4 and the advice option. This is where you're really ensuring that the client can make an informed decision about which policy to purchase. Now, in a really ideal world, you may well have a number of options to choose from. In some ways, that raises the stakes for the broker because they need to make the client aware of differences between policies and the cover they provide. On any basis, I think a broker has an obligation to explain the scope of cover by reference to what's covered under the insuring clause and perhaps any endorsements which are brought in to increase the scope of cover. Equally, the client needs to know about what is not covered, and that will probably be exclusions and, again, any endorsements restricting the scope of cover. So the advice, excuse me, needs to cover limitations or restrictions. So that could be retroactive dates, and it could be any specific endorsements. Onerous or unusual conditions are really important. They may be ones where it is apparent that it might be difficult for the client to comply with them, or perhaps that is something that would not ordinarily be seen in an insurance policy of this type. And finally, to advise on the terms and conditions that must be complied with as a prerequisite to the policy responding to a claim. Often referred to as conditions precedent, they may include, for example, the notification conditions around claims and circumstances in a claims made policy. Now, one point that we're often asked about is whether a broker can give standard template advice. And it's really a difficult one to deal with because there isn't a straightforward answer on it. We do have conflicting case law on the topic. So in Jones and Envirocon, the judge found that a broker's documents to show advice given to the policyholder about their disclosure obligations were inadequate, and the judge was not satisfied that a broker could simply rely on written standard form explanations. The judge in that case said a broker needs to ensure its client understood the advice. Now, in the same year, a different judge heard the case of Synergy Health and CGU and found slightly different approach to this. There was no definitive requirement in that judge's view that a broker has to give oral advice, and it is necessary to look at all the circumstances. And that finding was followed up in Avondale Exhibitions and Arthur J. Gallagher in a more recently reported decision. Now, what does that mean? Well, really, the adequacy of your advice is going to have to be assessed on a case-by-case basis. And I think it's fair to say that standard form advice probably is necessary and it is appropriate for certain issues. So going back to the fair presentation issue I talked about earlier, it may be around advice on how to deal with making sure that sums insured are correct. But I really do think, and I think this pretty strongly, standard wording can only go so far because not every risk is the same and not every policyholder is the same. Some clients are going to have a greater or lesser understanding of insurance than others. And that is where the Jones and Envirocon understanding aspect comes into play. Ultimately, looking at the case-by-case aspect, if you've got some specific advice buried away on page 15 or 16 of your generic advice note, a court is going to find it difficult to find that that was adequately or appropriately drawn to the client's attention. So risk management tip number 5 for the day, give the advice, record it in writing. It's probably the words we use most often when talking to brokers. That need to record is particularly important if you're giving advice on the phone. and if possible, and to address the Jones and Envirocon concern when discussing the advice, record that the client understood it, assuming you've managed to persuade them that they do understand it. So finally, and binding the risk, you might say on the face of it, this is pretty obvious. I mean, if you do not bind a risk, there could not be a clearer breach of duty of care to your client. And so really, it's probably not the major area of failing that we see, but risks do arise and issues do cause problems in this area. So firstly, if a risk is impossible to bind, that is one thing, but the onus is on the broker to promptly advise the client of the position so the client can consider their options. It might be that a more restrictive policy exists than what the client had particularly hoped for. If that still meets the client's needs, it may still be appropriate. You may, for example, be able to obtain a policy with a lower limit of cover than had been hoped for. And I think that restriction needs to be explained so the client can understand what is available and what is appropriate. It may be that you're unable to find cover because you don't have access to all possible markets. And it may be then that you need to consider involving a wholesale broker. I've seen brokers who involve a specialist wholesaler to place a particularly tricky part of a program, for example. So you might look at outsourcing the professional indemnity aspect of a wider commercial program. And that may enable you as broker to maintain the relationship with the client and add value to the proposition that you can provide. In the worst case, and this goes back to what Liam said earlier about fiduciary duties and not putting your own interests above the client's, it may be that you have to point the client elsewhere if you cannot find the cover that they need. And then finally, just around midterm adjustments and renewal, arranging suitable insurance cover doesn't stop on day one. We do often see claims arising where a client approaches the broker to make some form of midterm adjustment. So they might be looking to add a vehicle or a property to the schedule. But what we see is not only a problem at that stage, so maybe the information doesn't go onto the schedule as appropriate. We often see gaps in cover occur at renewal, where an account exec looks at last year's submission without properly checking the system to ensure that the developments over the course of the year have been dealt with and are addressed in that renewal. And if that happens, that's going to fall to the broker and not the client. So our sixth and final risk management tip of today, think about other ways to access markets and don't take your eye off the ball. After the risk is bound, the job does continue. So to conclude, we've given a number of risk management tips today, but they essentially revolve around these. And number one is really critical. If the advice isn't recorded in writing, if you haven't got a contemporaneous record of what was said, the case law shows that judges will find it very difficult to accept that you gave the advice you say that you gave. Communication is critical, whether that's with your client, with the insurer, with a wholesale broker, or even internally. These are the touch points at which we see claims arising because communication hasn't been clear or effective enough. You need to be ensuring you're obtaining relevant information from the correct people. And if you're really struggling to place the risk, I think you need to be open to finding other ways to access the market. So that's the main part of the presentation done. We'll hand over to Harriet now. I think she's been keeping an eye on the Q&A and has a couple of questions.
Thank you very much, Ben. We're slightly tight on time, so I'll be as swift as I can as there's several to deal with. I'll take a couple of them. Question to Liam, please, if I may. How do you balance the need to make detailed notes of advice and getting the client to approve them when you have a client who won't fully engage?
That's a question we were often asked. It's not an easy job. The client will see this as it's a distressed purchase. It's paying money away for something that may not see the value in until it gets a claim. What we often say is when you've got a client that isn't engaging, please do the note, please send it, please take those steps, because that's when we come to defend these claims, that's the important bit of evidencing what steps have been taken and also evidencing the client's understanding, because we'll look at the note and we'll look at what advice was given and how clear it was to demonstrate that understanding. If the question is asked, please let me know if there's please confirm the accuracy of this note, etc., etc. You're asking the client to take a step before you as a broker can move on. So one neat way of avoiding that scenario is where you put the onus on the client to do something, to take action if there's something incorrect or if something is missing. And as Ben says, if you explain really clearly that this is the information that we're going to rely on to go and get you an insurance policy, I'm not sure what more you can do as a broker, as long as you've told the client, this is the deadline, this is when you need to say something, or I'm moving this on because I'm assuming it is accurate and there's nothing further to change.
Thank you, Liam. And just a quick yes or no from both of you, if I might. Is the test of the reasonably competent insurance broker subjective or objective? One or other?
It's objective, but it will be assessed by reference to expert evidence, and so there will be an element of subjectivity brought in that the judge would then have to consider, but it is an objective test.
I just knew you'd bring in the both if you could. But thank you very much. On that basis, we really have come to the end of our road at the moment, and I'll pass the baton back to Ben. Are you closing down today?
I will.
Yeah.
If there are any outstanding questions, we will endeavour to reply by email. Just to let you know, the next episode of The Box is going to be on the 16th of January. It's going to be hosted by colleagues James Thompson and Bradley Needham. James and Bradley are going to talk about the recently reported decision in Infinity Reliance and Heath Crawford. And without giving the game away too much, several of the issues that we've talked about today came into play on that case. So it will give you some practical pointers about how these wider issues that we've talked about can come into play in that claim and trial scenario. So the invite will be coming out this week, so watch out for that one. Otherwise, thank you for joining us today. Please do complete the feedback form. That will be on your screens when you sign off. And if you do want to provide topics, we are always open to considering what else we can talk about and what else we can do to satisfy what your demands and needs, if you like. So thank you very much for coming today, and I hope you have a lovely Christmas when you get there. Thank you.